morning, everybody. I have an application for postponement brought by Minister Gordhan. Where he, in effect, applies for the postponement of his cross-examination by Mr. Tom Moyane's counsel, which was supposed to happen today. He says he applies for an order that he must appear on the 31st of August 2020, alternatively on a date to be agreed by all parties. Let me have the appearances.
Good morning, Chair. I am A.E. Franklin, SC, the evidence leader for this segment of the matter.
Yes, thank you, Mr. Franklin. Hang on one second. Do we have somebody who sanitizes today? If there is nobody who sanitizes, you can just speak from where you are. Yes.
Good morning, Chair. I'm
Good
Ms.
morning.
Mbata and representing Minister Gordhan in this application.
Yes.
I'm from the Office of the State Attorney.
Yes.
Thank you.
You're moving the application for a postponement.
Yes.
Well, this affidavit, which has been deposed to, not by the minister himself, by somebody who says she is the minister's chief of staff.
Indeed so.
All it says is that the minister is not available due to cabinet commitments. There does not appear to be any information about why those commitments are more important than appearing before this commission.
Chair, those were my instructions that the minister is not available due to the commitments that he had at the cabinet. So,
Mere cabinet appointments on their own can't be more important than appearing before this commission. There would need to be something more than just mere cabinet commitments. This commission has got a very limited time to finish its work. And cabinet commitments are work like everybody's work commitments. If everybody is going to say, I have work commitments, I can't appear before the commission on this day, then we are not going to finish this job.
with due respect, Chair, I think probably the application was not more into detail as to exactly what the minister is doing or what held him up at the cabinet. But I of the view that he does respect the commission and he has due respect for what is taking place here, and he does want to come and give evidence if.
And what I do know is that the president has told me that he has told the cabinet ministers that whenever anyone is required to cooperate with the commission, they must cooperate. It may be that our solution is just to make sure that summonses are issued against anyone who must appear before the commission, because there are just too many instances where people say they can't appear before the commission on a particular day. And I see here that the order sought is that his cross-examination should be
On the 31st.
postponed to the 31st of August 2020 or to a date to be agreed by all parties. I'm not going to postpone this matter to a date to be agreed by all parties, because if we are going to work like that, we won't get anywhere. Lawyers are busy, and if we are going to do that, we can't do our job. So I will postpone it. I'm not happy. I will postpone it to a date that I will fix that accords with the program of the commission. And I saw that Mr. Tom Moyane's position was that although his counsel is not available from their side, they say they are not asking for a postponement, but they are, and they accept that the unavailability of counsel is not a good ground for a postponement. I'll postpone it. We'll fix a date, and if Mr. Moyane doesn't use that opportunity, he might forfeit his right to cross-examine, but we'll have to make sure that the minister is here on the date that is fixed, so that we want to finish the work of the commission. And we are a few months away from the end of the term of the commission, so we've got to use all the days that we have properly. So I think Mr. Moyane's counsel, okay, you may sit down.
Thank you,
You
Chair.
might wish to say something.
Thank you, Chair.
Yes, just put on your mic. Not mask, mic, microphone, yeah. No, the mask, yeah.
Thank you, Chairperson. My name is Mfesane Kasiboto. I'm an advocate at Dumanoko Group of Advocates. I record my appearance on behalf of Mr. Tom Moyane. Our position is as simple as you've recorded, Chairperson, that in principle we're not opposed to the application for the postponement. Be that as it may, we thought we'd honor the opportunity we've been granted by the Commission, that if you take the position that we proceed today, we're more than happy to. But with that being said, we understand the difficulty, which is that Mr. Odan is not in front of the Commission for cross-examination. And in principle, we accept that we're in your hands. We're happy with the 31st of August. Be that as it may, we want to place it on record as well that we're happy, we're at the hands of the Commission. I mean, obviously there'll be issues with the availability of lead counsel, because you'll understand, given the length of the matter, the involvement of counsel, there might be difficulties having to find counsel within a short period of time. But with that being said, we want to place it on record that we'd avail ourselves at the date that the Commission will decide, and if alternative means have to be made, we're happy to do so.
Okay, no, that's fine. Thank you.
Thank you, Chair.
Yes. Mr. Franklin, do you want to say anything?
Thank you, Chair. Nothing specific other than to echo the sentiments of the Chair that it is regrettable that the matter has to be postponed. The practical solution, as the chair has already decided, is to set another date, and I understand that that will be done in communication between the Secretariat and the chair.
Yes.
That is all I have to say.
Yes. No, thank you very much. I'll postpone it, and the date will be determined soon, and the date will give everyone enough time to make sure if they were not to be available, they make themselves available. The cross-examination of Minister Godan, which was scheduled for today, is hereby postponed to a date that is yet to be determined. Those who wish to be excused are excused. Good morning, Mr. Soni.
Morning, Chairperson.
Yes. Are you ready?
Yes, we are. Chairperson, we have asked Mr. Madimpe Mogashoa to give his evidence today. You will recall that earlier in July, we had intended calling Mr. Mr. Mogashoa, but he couldn't come on account of the fact that he was not feeling too well on that day.
I think bring your mic a little closer. Your
Yes, as you please.
voice is going down.
Yes.
Yes.
Sorry.
Yes. Well, he gives evidence in relation to Prasa, and
That is
he'll
so.
be giving evidence in relation to his role as the attorney for Prasa in regard to, among others, I guess, I don't know whether it's among others, but the SIAC claims or cases and his interaction with the Prasa legal team, as well as with the chairperson at the time, Judge Makubela now.
That
Yes,
is,
that's what he will be giving evidence about.
that is so, Chairperson.
Yes.
Chairperson, may I place on record at the outset that last night the Commission received an objection from Judge Makubela, who said that she'd been the notice that she'd been given that Mr. Mogashoa would be testifying today was too short. Place on record that she was given notice on Saturday. Also placed on record, Chairperson, that the decision to call Mr. Mogashoa was made on Friday, and that's when all the parties, including Mr. Mogashoa, was decided.
Well, I must just indicate that the calling of Mr. Mogashoa today or sometime this week emanated from me in order to try and make sure that we use the time available as much as possible. It did not emanate from Mr. Soni or anyone else. And to the extent that Judge Makubela might have been given short notice, one, she will have access to the transcript of Mr. Mogashoa's evidence, and actually the acting secretary should send her a letter indicating to her how to access the transcript of Mr. Mogashoa's evidence. And in this regard, also, it's to be noted that she has not made any application for leave to cross-examine Mr. Mogashoa. Indeed, other than the fact that when she gave evidence, she denied having asked or instructed Mr. Mogashoa not to speak to the Prasa legal team about the CIA claims. Other than that, as far as I know, she has not filed any affidavit disputing anything in Mr. Mogashoa's affidavit. Is that your understanding as well?
That is the position as I know it.
Yes.
Chairperson, yes.
So other than that one denial, she hasn't sought to tell us that she disputes Mr. Mogashoa's affidavit, or at least she has not done that by way of filing an affidavit, despite the fact that she has had Mr. Mogashoa's affidavit for a long time. Yeah. So I don't think that she should be prejudiced in any way other than that she could have come to sit here while Mr. Mogashoa was giving evidence. She would not be allowed to cross-examine him because she hasn't applied for leave to cross-examine. All she would do is just listen, and she will be able to read all the evidence in a transcript. Yeah. So I just thought I must clarify that the decision didn't come from you. It came from me.
As you
Yeah.
wish, Chairperson.
Okay, all right.
May we have you to call on?
Yes, please administer the oath of affirmation.
Please state your full names for the record.
Madimpe Mogashoa.
Do you have any objection to taking the prescribed affirmation?
No.
Do you solemnly affirm that the evidence will give will be the truth, the whole truth and nothing else but the truth? If so, please raise your right hand and say, I truly affirm.
I truly affirm.
Thank you.
Thank you very much. You may be seated.
Mr. Mogashoa, it's common cause that you are an attorney and that you have acted for Prasa in certain matters. I'm just placing that on record.
Yes.
In relation to the evidence you are about to give today, have you made an affidavit?
Yes, I have, Chair.
Have you that affidavit in front of you?
Yes, it is in front of me.
Chairperson, the affidavit is in bundle G. It is marked exhibit SS13, and it starts at page 1, Chairperson.
So the bundle is bundle G,
Yes.
and
Exhibit SS13, it's the first
yes,
document in that bundle, Chairperson.
yes, and you would like Mr. Mogashoa's affidavit to be admitted as exhibit
SS13.
double S13.
As you wish,
That affidavit, Mr. Mogashoa, does it appear on page 1 and goes up to page 19? If you look at the red numbers on the top right corner of the pages.
That is correct, Chair.
Yes, and that signature is your signature above the certification.
It is my signature, Chair.
Yes, thank you. Mr. Mogashoa's affidavit is admitted as Exhibit S13.
As you please. Ms. Mogashoa, could you very briefly tell the chairperson how it came about that you made this affidavit? Just very briefly.
Okay, Chair. I received a call
I'm sorry, Mr. Mogashoa, please bring the mic a little closer to you.
this way.
Yes, I don't know if it moves. If it moves, I want to be a little closer even than that, or maybe you move your chair. I hear better when it's not too far away from you.
Okay, Chair. I received a call, it must have been around April of this year, from Mr. Rangata, who indicated that in the proceedings, officials of Prasa came through to the commission to give their evidence, in particular in relation to some of the matters that my firm, the Mogashoa attorneys, the matters that Mogashoa attorneys was involved in, and that there were in particular matters in relation to the CIA, what I see is referred to as the CIA group of companies. She then asked that it is only courtesy that she requests that I assist by making my own affidavit available. I was subsequent to that given a copy of Ms. Ngoye's affidavit, and I think at that time she was either still testifying or had just finished testifying, but what I was given was a copy of her affidavit. I'm made to believe that it forms part of the documents I might be talking to this morning. I then received a letter from the Commission explaining precisely what was needed from me and the firm I am part of. And because the last time I was involved in the matters was way back in 2017, 2018, I kept on indicating to Ms. Rangata that I needed more time because I had to plow through documents, most of which we have already archived. But in answer to the question, Chair, that's how I got to eventually formulate and settle this affidavit that is before us now.
In regard to the contents of your affidavit, was the Commission legal team or anybody from the Commission involved in the formulation of your affidavit?
I formulated and settled the affidavit myself, Chair.
Now, in your affidavit, you referred to the affidavits by two Prasa officials, Ms. Ngoyi, whom you've mentioned, and was there a second person whose affidavit you received?
I received the affidavit of Ms. Ngoye initially when I was approached to be of assistance to the Commission, and I think subsequent to that, but before I could settle the affidavit as requested, I was given the affidavit of Mr. Dingizwayo. I believe at that time, Mr. Dingizwayo had not come through to the Commission to give his evidence, Chair. I may have been placed in possession of Ms. Ngoye's transcript, but I have not seen Mr. Dingizwayo, but I believe he has given his evidence. So I was in possession of the two affidavits at the time of formulating this affidavit.
Now, in the affidavit, did you read the affidavits that were given to you?
I went through both affidavits that were
In
given.
their affidavits, they mentioned their interactions with you and your firm and your interactions with Prasa in relation to the Siaya matters. Just in general, what is your response to the averments made in their respective applications insofar as it concerns you and your firm?
Okay. Let me start by explaining that I understand and I understood at the time I was asked to prepare an affidavit, the role that I had to fulfill by offering explanations which Mr. Ngoye and Mr. Nikizwayo may not have had enough information around. As my affidavit says, and in the normal, ordinary course of accepting instructions from Prasa Chair, which we acted for, I received, I think during the period of 2015, it must have been around September, I could be wrong, but the dates are in my affidavit. I received about 4 summonses, all by different companies, which I see we refer to as the SIA Group, and all of which were in respect of claims by the SIA Group against Prasa, purportedly as a result of services rendered through a variety of contracts or agreements that Prasa and CIA may have gotten themselves involved in. And I believe that in the beginning of 2016, the year that followed, I was then instructed on 2 more, to defend 2 more of such summonses by entities that are perhaps part of what we call the CIA Group now. Now, my instructions, Chair, were that our firm should defend Prasa in as far as the summonses were concerned. I recall very well that during 2015, just after we had entered appearance to defend in respect of the 2015 case numbers, which I speak of in my affidavit, our opponents, and I think my opponent colleague was Mr. Matopo of Matopo Attorneys, he represented the CIA group of companies. They immediately proceeded to file an application for summary judgment in respect of all of the matters. Now, naturally, through consultations with client, it came out that client had a basis to want to defend those 4 matters at that time, and that is what the legal team, which our firm was a part of, carried on to then file opposing papers in the defense of Prasa and in illustrating to the court at the time that Prasa had bona fide defenses to defend the matters. I suppose it's on record now that the summary judgment applications were successfully opposed, and then the parties then went on to litigate. As for instance, I may have been instructed by our client to litigate in the manner that we did through the various stages of such litigation. And I think in 2016, when we received the 2 additional summonses, we went on to file our appearances to defend as instructed, and my opponent, I think, in this case, did not go on to file applications for summary judgment in respect of such matters. And We then went on to exchange pleadings, and one can accept that in that respect, there would have had to be many occasions during which my firm would consult with Prasa and Prasa officials, and I think in particular it will be Ms. Ngoye, Mr. Dingizoyo, and Ms. Mukotedi. I had received all of these instructions from Ms. Mukotedi through, I believe, Mr. Dingizoyo's instructions. In the process of dealing with the litigated matters, it became apparent that the contracts that opponents relied upon made reference to arbitration as one way of having the matters adjudicated upon. And I think the parties at some point during 2016 or 2017 agreed to then have the matters referred for arbitration. My affidavit speaks about all processes thereabout, and I think Ms. Ngoye's affidavit speaks about such processes thereabout. And the parties agreed, after obviously some bit of tiffing and towing about who the suitable arbitrator would be. We eventually agreed on instructing retired Judge Fritz Brand. I recall that we subsequently had a pre-trial, pre-arbitration meeting with Judge Fritz, at which we then agreed on the many various steps that the parties would follow in preparing the matters for the arbitration hearing. And if my memory serves me well, we had intended to sit around certain dates of September of 2017 so that we argue the cases as pleaded in the numerous documents that we had at our disposal.
Mr. Son, it will be important to let him talk to each claim to say what was it about. And I mean, the question of their defense is in the public domain because pleas were filed, as I understand it, was what the defense was or defenses were, how much was claimed, what was that claim for, what was the defense of Prasa, just briefly.
Yes. I'll do that in a moment because he does, there is a report from Mr. Mogashoa which I want to deal with in that regard, Chairperson.
But it's important as whoever is listening, as they follow, they know what claims we are talking about. Yes. It's easy for all three of us because we know, we have read this, but somebody who is listening doesn't know what are these claims for, and if we go too far without explaining them, they are disadvantaged.
I just wanted to cover a formal issue.
Yes, no, that's fine.
The question I had asked you, and where you gave the history of the matter, was, did you read Ms. Ngoyi's and Mr. Dingiswayo's affidavit? They make a number of allegations. I'm just asking, are you in agreement with those allegations they make in their affidavits, or do you disagree with it, just in general?
The Chair, there will be certain aspects of their affidavit or their affidavits that I disagree with, and I do state that very clearly in my own affidavit where you I think they did not quite capture the facts of the matter. Yes. In line with what I know the facts to be. So every aspect of their affidavits that deviated from what I know about these matters, I would have I would have had to deal with it.
So I think
in
your
my
answer,
main
I
affidavit.
think your answer, Mr. Mogashoa, should be your attitude to the allegations made in Ms. Ngoye's affidavit is as reflected in the affidavit, because there you deal with that. Those that you admit, you make that clear. Where you think it's not, it doesn't give the full picture as you understand it, you have also dealt with that, is that right?
That's correct, Chair.
Yeah, and then Mr. Soni can take you to those if it's necessary.
Can I just ask you to look at paragraph 7 of your affidavit, Mr. Mogashoa?
What paragraph?
Paragraph 7 on page 3, Chairperson.
Okay.
You say in the first sentence, I had an opportunity to consider the affidavits of Ms. Ngoyi and Mr. Dingizwayo, as well as the documents in the group. And then just read the second sentence, please.
I confirm that the amendments contained in this affidavit are a correct recollection of the events that took place, except where I otherwise in this affidavit prefer better clarity and or put issues into their proper perspective in areas where our firm's involvement was concerned.
Yes. And then if you look at paragraph 8, you make one point about an allegation made by Mr. Dingizwayo that the settlement that had been concluded in December 2017 was a secret settlement, and you say there was no secret settlement. Is that the extent of your dispute between yourself and Ms. Ngoyi and Mr. Dingizwayo, except where something else appears in your affidavit?
Well, yes, except where something else appears in my affidavit, I had to categorically state that the assertion that in as far as our firm was concerned, the assertion that the settlement processes were done secretly, I did not quite think that that would be correct in the context of our firm's involvement in the matters.
To the extent that when Mr. Dingizwayo referred to a secret settlement or anything along those lines, to the extent that he may have meant that it was a settlement in which the legal department of Prasa, of which he was part, had not taken part or had been excluded, would you be able to comment on that?
I would accept that proposition, Chair, if he means it in a sense that perhaps the legal department was not aware.
Yes.
About what was happening.
Yes.
About the settlements at that time.
Yes.
I don't have a problem with that proposition.
Okay.
I'm going to come back to that, Chairperson. I don't want to be
That's
asking
fine.
leading questions, but that is
Yeah.
an important issue.
Yes, that's fine.
Now, in regard to the 6 matters that you've mentioned, Mr. Mogashoa, did you at any stage do a report for Prasa?
You mean in the ordinary, I just want clarity on your question. You mean in the ordinary course of dealing with the matters? The mission as
In 4, Mr. 1 is 7B.
and which page would that be?
If you look at page 322, that's MN4.
I have it in front of me. Yes.
Now, what is that document?
This is a report compiled by our office.
Well, who from your office?
I prepared the report with my colleague, Nabeka Zimbabwe.
What was that report about?
We were, prior to this date, requested by the legal department to prepare a status report in respect of all of the matters our firm was defending for Prasa at that time. I think in my discussions with Ms. Ngoye or Mr. Tingizwayo, I was made to believe that the board wanted to have a quick update on the status of the litigation of the matters related to the CIA group. And in that way, we then, Ms. Mbebe and I then went on to prepare this report. I have it dated the 21st of November. That is correct.
The summons, paragraph 1.2, would that be correct? Point 1, page 3, the claim is founded. Could you just indicate what that, and then at paragraph 5.1, at paragraph 2.1.3, you indicate what?
19,000 raised the issue of jurisdiction in that clause 20 of the agreement upon which the plaintiff relies. Disputes between parties must be referred.
And then you indicated that eventually the matters were referred.
So yes, Chair, in answer to your question, there was an agreement to also refer the so-called settled matters for arbitration at that time.
Okay, maybe you can finish.
In answer, I will go through all of them, but in
Yeah.
answer to the question, Chairperson, without leading the witness, that is indeed the position that the jurisdictional point was taken in respect of all the contents.
Okay, you are away from the mic. As a result, I
sorry.
can't hear.
Yes, sorry.
Yes, I didn't hear. Just repeat the point.
The jurisdictional point was taken in regard to all 6 claims.
All 6 claims.
Yes.
Oh, okay. Thank you.
All right, then, Mr. Mogashoa, if you look at paragraph 2.1.10, you indicate what the second defense was in the plea that had been filed in the High Court. What was that defense?
Correct. We say in paragraph 2.1.10 that the second defense raised in the plea is that the services indicated to have been rendered on the invoices upon which the plaintiff relies are not of any of the services listed in the annexure POC or POC 3. In other words, the payments claimed for by plaintiff under these summons are not authorized by the consultancy agreement upon which the plaintiff relies, and on that basis, defendant is not liable to the plaintiff on such amounts.
So, just to clarify that, would it be correct to say that Prasa's defense in relation to this claim as reflected in paragraph 2.1.10 was that CIA may have performed those services, but those were not services that Prasa had asked CIA to perform?
Indeed so, Chair.
Yes, and that CIA could not claim from Prasa payment for services that had not been agreed should be performed by CIA.
This things happened a long time ago, Chair, but I would imagine that we had difficulties with the fact that what we came across as evidence of amounts that the CIA group was saying were outstanding. The invoices and what the invoices articulated by way of the services rendered were not in consonance with the agreement, and in particular annexure POC 3. So this may have been confirmed by our client during the various consultations we may have had with them, that they had challenges with those invoices as they did not seem to relate to any of the services as may have been prescribed by this annexure to the agreement.
Okay.
And then at paragraph 2.1.11, you articulate what the third defense was. Could you indicate to the chairperson what that was, even if you just read paragraph 2.1.11 into the record?
Okay, we say, Chair, in paragraph 2.1.11, that the third defense raised in the plea is that the plaintiff is not entitled, I imagine, to interest because they did not demand payment of such various amounts on the date alleged in its particulars of claim, and therefore they are not entitled to interest with effect from those dates. I imagine it will be the dates of the invoices themselves.
Now, in paragraph 2.1.12, you refer to a further defense that was raised. Could you indicate what that defense was?
Chair, we say in paragraph 2.1.12 that the defense also relied on clause 11.1 of the consultancy agreement to allege that the invoices upon which the plaintiff relies are not in accordance with the payment schedule contemplated in clause 11.1 of the consultancy agreements, due to the fact that the amounts claimed therein are not the amounts provided for the payment schedule contained in Annexure B to the consultancy agreement. The premises, insofar as amounts claimed by plaintiff are not in accordance with the amounts provided for in the payment schedule contained in Annexure B to the consultancy agreement, the defendant pleads that the plaintiff is in law not entitled to claim such amounts in terms of the consultancy agreement, and the defendant is therefore not liable to the plaintiff in terms of the consultancy agreement upon which the plaintiff relies.
And then in paragraph 2.1.13, you raise a further defense in respect of reciprocal obligations. Can you articulate what that defense was, even if you just read it out?
Chair, in paragraph 2.1.13, we say that the defense also relied on the fact that clause 1.12.4 of the consultancy agreement created reciprocal obligations between the parties. The clause provides that the plaintiff commits an event of default if it does not deliver a certificate of occupation within a period of 20 days from the project completion date. The plaintiff has not delivered the certificate of occupation referred to in clause 1.12.4 of the consultancy agreement, and it is for this reason not in law entitled to enforce the consultancy agreement against the defendant.
And then in 2.1.14, you raise an even further defense. What is that?
We say in 2.1.14, Chair, that the plea also contested the lawfulness of the variation of the consultancy agreement to the extent that it is not contemplated in clause 23 of the agreement.
And 2.1.15 indicates what your last plea to this claim was, and what was it?
We say there, Chair, that lastly, the plea dealt with the defendant's denial of the fact that the services the plaintiff alleges to have rendered are in consonant with services listed in POC of its particulars of claim.
Now, earlier on, you indicated that the claims were not consonant with POC 3. Was this a separate defense as well? Because here you refer to POC 2.
I just want to read 2.1.5 again. We seem, my understanding of this paragraph is that we seem to also deny that the services rendered are in line with the services as may have been listed in Annexure POC2 of the particulars of claim.
Yes. I'm just going, if you look at paragraph 2.1.10 on the previous page, you'll see there's a reference to POC3. I'm just saying that it appears as if there were 3 sets of particulars of claim, and that 2.1.10 referred to one, and this referred to yet another.
I suppose you mean annexures and not...
Sorry, annexures, yes.
Yes. So yes, from the reading of my report, indeed, there would have been POC annexures, and we seem to be saying both their reliance on POC3 and POC2 were found to be wanting in our interpretation of the documents in their totality at that time.
Mr. Mogashoa, let me just try and understand. These defenses were based upon what? In other words, how did it come about that these defenses exist?
We would have had to consult.
Well, you would have not.
We went on to arrange on many instances and occasions consultations with clients. Documents were made available to us. Information was shared with us by members of the particular unit, which unit would purportedly have received such services as may appear in the allegations in the particulars of claim. So the defenses were formulated as a result of consultations and as a result of documents that were availed to us as legal team. And naturally, that which followed was that we repeated all of these defenses in the plea as may have been amended that we filed on behalf of Prasa.
Now, in regard to the drafting of the plea, this is a claim for 27 million rand. Did you have counsel?
Yes, we had counsel. I think I do say in my affidavit that initially in 2015, we were instructed to brief Advocate Mike Maretz, SC, and with him, Kennedy Tsatsawani, as his junior. And I think it was up to the point we argued applications for summary judgment. But I think from then onwards, we were instructed to proceed with Advocate Tsatsawani. I can't remember if at that time his silk status had been deferred, but we proceeded with him, and over time, were instructed to get a junior for him.
I'm just trying, sorry.
At the time of filing these pleas, yes, Advocate Tsatsawani and Mawande Seti.
I'm just trying to find out whether counsel drafted the pleas.
It would have been counsel who drafted the pleas, correct.
All right, then let's look at the next case, which you set out at paragraph 2.2 of Annexure MN4. And what case number is that?
We are saying here that it is case number 73933 of 2015.
And who was the claimant in this matter?
The plaintiff in this matter is DB Consulting Engineers Pty Ltd against Prasa.
And in paragraph 2.2.2, you indicate what the basis of this claim was. Could you read that into the record?
We summarize the plaintiff's case to be that on or about the 4th of December 2013, and at Braamfontein, Johannesburg. The plaintiff, represented by its managing director, Mackenzie Mabunda, and the defendant, represented by its chief executive officer, entered into a written accelerated infrastructure refurbishment project consulting agreement.
I'm just asking if you recall, who was the chief operating officer, the defendant's chief operating
Chief Executive
officer?
Officer.
Chief executive officer, sorry.
In 2013, it may have still been Mr. Lucky Montana. It may have still
Well,
been
in
Lucky
2013,
Montana.
it certainly would have been Mr. Montana,
Yes. Yes.
because he left in 2015, if I recall correctly. Or was it 2014? But in 2013, I'm sure it was still him.
Yes.
Yeah.
And if you look, Mr. Mogashoa, if you turn to paragraph 2.1.2, it's on the previous page 323, and you look at paragraph 2.1.2, you do name the CEO there.
Yes, that is indeed so.
And who is the CEO then?
It says Lucky Montana.
Yes. And that agreement was 2014, and the chairperson is making the point that therefore in 2013, it must have been Mr. Montana as well.
Indeed, so I'm just not sure whether we left the information out regarding who the chief executive officer at the time was, or that this is just a caption of what the particulars of claim say.
If you look at the first line of the next page, that's page 326, and that's your paragraph 2.2.3, you indicate what the purchase price, the contract price of this contract was. What was it?
We say there that the contract price was 24,978,000 rand, inclusive of VAT.
And then from paragraph 2.2.8 on page 327, you indicate the basis on which the plea was founded. And what is 2.2.8?
Chair, we say in paragraph 2.2.8 that the amended plea raised the issue of jurisdiction in that clause 19 of the agreement upon which plaintiff relies provides that disputes between parties must be referred to arbitration, and that the present dispute had not been referred to arbitration.
This is the point that the chairperson was asking about. Did all the was the same jurisdictional point taken in respect of all the contracts? Certainly it was taken in respect of this contract as well.
Indeed so, Chair, if the report confirms that, because I think the report was done when our firm was still seized with the responsibility of defending the matters.
But at the time you drew up this report, you would have had everything in front of you.
We had everything in front of us, correct.
Now, 2.2.9, you indicate a further defense. What was that defense?
We say there that the defendant also denied that the agreement was entered into by its chief executive officer, and as well the correctness of clause 3.2 of the agreement.
And in 2.2.10.
I'm sorry.
Oh, sorry.
On 2.2.9, is that defense one that disputed the validity of the agreement that was entered into by Prasa's chief executive officer at the time, or was the defense that factually no agreement existed. Do you remember? Is that something you are not able to remember?
I can't quite remember, Chair, but just to assist, if I give regard to paragraph 2.2.9, we either did not have an agreement at all, or alternatively, we had an agreement that did not bear any signature of the Chief Executive Officer and or any other official from Prasa who may have been mandated to enter into such an agreement. So we disputed the existence of the agreement from my reading of 2.2.9.
Okay.
And then in 2.2.10, you raise a further defense, and what was that?
We say there that the plea also alleges that the defendant is not liable to the plaintiff due to the fact that the plaintiff failed to provide it with an occupation certificate as contemplated in clause 1.11 of the agreement.
Okay. And 2.2.11,
upon which the plaintiff for each of the invoices of Annexure B of the agreement is provided
in the previous one.
formulation of the defendant's defense.
Before we go on with the rest of the defenses, may I make or raise this with you? The chairperson had earlier asked you in respect.
I imagine it is because there was no agreement to refer to. We say there that of the services for which payment is claimed.
Right, and in 2.3.12, Chairperson, sorry, may I indicate, I understand it is tea time. I'm just wondering if I shouldn't finish this and then we could break for tea. It's just
okay, all right.
3 clauses.
Okay.
2.3.12,
In 2.3.12, we say that the defendant also admitted receipt of the plaintiff's invoices, but pleaded that the plaintiff did not render services for which the invoices were rendered, and that plaintiff did not deliver the deliverables contemplated in such invoices. It is pleaded further that some of the invoices submitted by the plaintiff do not fall under any of what the plaintiff alleges was the scope of works as contemplated in POC 1 and POC 2.
now this again harks back to what was said in respect of 2 other claims. In other words, there's a disjuncture between the claim and the annexures that the plaintiff had relied on.
That is indeed so.
Those are the defenses in regard to this claim. Chairperson, maybe this would be the ideal.
Yes, I understood you to say you wanted to just wrap up on that one before we...
Those were the 2.
Before we
there are
take
no more
adjournment. I thought let's take the tea adjournment, and when we come back, you finalize the remaining claims if you haven't covered all the ones you wanted to cover.
I thought we would cover all the claims, Chairperson, and it has an importance in relation to the fact that an agreement was reached.
No, that's fine. We will. All I'm saying is let's take the tea break now.
Yes.
And
yes,
when we
so,
come back, you can continue.
Yes, I'm sorry.
We'll adjourn for tea now, and it's 22 minutes past 11. We will resume at 22:12. We adjourn.
All rise.
Okay, let's continue. Switch on your mic.
Ms. Mogashoa, we just finished the third, the defenses to the third claim, you will recall, before the tea interval. Mogashoa?
Yes, I do recall.
Okay. Can we go to the fourth claim, which is reflected at paragraph 2.4 of MN4, which is your report on the CIA matters. That's at page 330.
Okay, I'm on it.
What case number was this?
We have got case number 47598 of 2016.
And who was the plaintiff or claimant in that matter?
It says here that the plaintiff is CIDB Consulting Engineers Pty Ltd against Prasa.
And what was the claim in respect of, if you look at paragraph 2.4.2 of your report?
We say there that the summary of their claim is that on the 31st of March 2011, at Braamfontein, Johannesburg, the plaintiff, DB International, GmbH, and the defendant concluded a written memorandum of understanding in terms whereof they agreed to cooperate according to the terms of the MOU in the field of integrated passenger and railway operations on the basis of the specific agreements for the benefit of the parties in order to improve various initiatives of technical and strategic cooperation in the following projects.
Yes. And then now that's an MOU, and then at 2.4.3, you indicate more specifically what the claim was based on.
We say there that the plaintiff alleges further that pursuant to the conclusion of the MOU, the parties entered into a written agreement on the 30th of July 2013 with the plaintiff duly represented by Ms. Solani Vuma and the defendant by Mr. Lucky Montana.
All right. Then you set out the defenses, which start at paragraph 2.4.8 on page 331.
Yes, we then state in our paragraph 2.4.8, Chair, that the defendant's plea indicated that in the light of the fact that the validity period of the consultancy agreement between the plaintiff and the defendant commenced on 15 July 2013, it follows that such validity period came to an end by no later than 28 February 2014. In the premise, there was no longer an agreement between the plaintiff and the defendant in terms of which the plaintiff could lawfully render services to the defendant and in terms of which the defendant would be obliged to make payment I'm sure we wanted to say to the plaintiff, due to the fact that the consultancy agreement upon which the plaintiff relies had come to an end by a fraction of time by no later than 28 February 2014. Accordingly, the defendant is not, in terms of the consultancy agreement upon which the plaintiff relies, liable to the plaintiff for any services allegedly rendered by the plaintiff after 28 February 2014 or for the damages claimed in these proceedings.
Right. Then you raise three other defenses at paragraphs 2.4.9, 2.4.10, and 2.4.11. What are those?
We, in those paragraphs, say that the first one, the plea also denies that the plaintiff ever carried out additional scope of work, which was not contemplated in the consultancy agreement upon which plaintiff relies. Alternatively, that the work that plaintiff alleges to have carried out was authorized by the defendant. The defendant also denies that the plaintiff ever presented a concept design to the depot steering committee. Secondly, we say that the plea also raised a defense that by the time the motivations referred to in the plaintiff's particulars of claim were submitted, the term from the consultancy agreement had lapsed and that it was no longer competent for the plaintiff to submit the motivation/variation orders. And lastly, we say that the plea also alleges that the plaintiff acted in an unreasonable and negligent manner in believing that the services were rendered as contemplated in the consultancy agreement, and that the variation orders were not authorized by the defendant, and that plaintiff failed to realize that the consultancy agreement contract had lapsed.
Then the fifth claim is reflected at paragraph 2.5. Who was the claimant in that matter?
The claimant in the matter of the plaintiff is Rail Solutions, Pty Ltd, against Prasa, and I see that the report says that it's under case number 47597 of 2016.
Yes. And if you look at paragraph 2.5.5, you'll see what the amount of that claim is, or the amount of the contract.
The paragraph states that further that the parties agreed that the plaintiff will render services to the defendant in terms of the aforementioned agreement whose contract price was an amount of 69 million rand, inclusive of that.
And if you look at paragraph 2.5.8, that reflects, that's on page 333, the amount of the claim. And what was that amount?
Sorry, Chair, which paragraph?
Paragraph 2.5.8 at the top of page 333.
Okay, our paragraph says that it is as a result of this breach of agreement that plaintiff now claims that the defendant is indebted to it to an amount of 21,626,138 rand.
I'm sure you meant alleged breach there.
Well, yes, Chair, I'm sure it's repeated in other paragraphs that it's an allegation.
I'm sure CIA would have been happy to see that you didn't say alleged, you said breach.
Yes.
Yes, Mr. Soni.
As you please, Chairperson. And then at paragraph 2.5.10, you set out the first leg of the defense, or the first defense.
We say there that the defendant's plea disputed the fact that plaintiff's current claim is based on a consultancy agreement, and same is therefore irrelevant for purposes of this proceedings.
All right. And at 2.5.11, you raise a further defense.
We state there that the plea further denied the conclusion of the additional service agreement, and in the alternative, we pleaded that in the event that it is found that the additional services agreement was concluded between the plaintiff and defendant, then in that event, the defendant pleads as follows: that the conclusion of the additional services agreement was not duly authorized by the defendant, that Sonic Baltak was not duly authorized to conclude the additional services agreement, that the defendant did not at any stage represent to the plaintiff that Sonic Baltak was duly authorized to conclude the additional services agreement referred to in paragraph 11 of the particulars of claim, and lastly, that the additional services agreement upon which the plaintiff relies is not valid and binding upon defendant, and it is in law unenforceable against defendant due to the fact that its conclusion was not duly authorized by the defendant.
And then at 2.5.12, you raise a further defense is set out. What is that?
We say there that the defendant also alleged that the contents of Annexure S3 of the plaintiff's particulars of claim does not indicate or suggest the alleged conclusion of a written agreement, and that same cannot be construed to constitute a written agreement.
And paragraph 2.5.13.
We say there that the defendant's plea admits that HAC did not submit a variation order, but defendant denies that same is linked to the alleged additional service agreement.
And in 2.5.14 and 15, you raised two further defenses are raised. What are those?
We're saying defendant also denied that the plaintiff ever submitted a report setting out services rendered and that the invoices submitted by the plaintiff were ever adequately explained to the plaintiff, or by the plaintiff rather. And we then also say that the defendant denies that it made any representations relating to approvals, authorizations, and variations in relation to services allegedly rendered by the plaintiff.
Okay. Then the sixth claim is reflected at paragraph 2.6. But before I ask you to set out what that claim is, can I ask you please to look at paragraph 2.6.8 on page 334 in relation to that claim?
Yes, I see the paragraph.
What does that say?
The paragraph says that on the 13th of April 2016, we received correspondence from our opponents who informed us that their client had been paid the full amount that they were claiming and proposed that the defendant tenders the cost of the proceedings. We thereafter sought instructions from client to no avail.
But effectively, what was the effect of the fact that payment had been made?
The matter, in as far as the litigation is concerned, was not proceeded with.
In other words, it had become settled effectively.
It had become settled. I believe that at some point, client confirmed that position, and we went on to close our file.
Now, Mr. Mogashoa, what was the purpose of your drawing up this report?
Maybe before that, it would appear that in all of these claims, CII claims that you have covered, in all except one, the plaintiff was the same, namely CII, DB, Engineering Consulting Pty Limited, and the only one where the plaintiff seems to have been a different legal entity, though also under CII was the one called CII Rail Solutions Pty Limited. Is my observation correct?
Correct. It is indeed so.
Okay.
As you wish. So, Ms. Mogashoa, come back to my question. What was the purpose of this memorandum report, whatever one wants to call it?
We were instructed by the legal department of Prasa to prepare the report, and in my understanding, the board or the chairperson of the board had called for it. But I remember we were told that there was a need for us to urgently prepare a status report in respect of all of the CII matters that our firm was defending.
Now, based on this report and based on the defenses that had been raised, and having regard to the instructions you had received, what was your view, you were the instructing attorney, of the prospects of successfully defending these claims?
Before he answers, if he is able to answer, that's fine. I'm just thinking that if you are involved in the matter, yes, you might have discussions with your client, yes, and for whatever happens, you might not want to tell other people what you told your client about the merits.
Yes.
But if he feels comfortable, that would be fine.
Yes. No, I understand
You understand
perfectly.
that?
Yes, yes,
Yes,
Chairperson,
yes, and it may well be that an opinion on the prospects may be based on the legal department of Prasa, what they took, or on somebody independent other than the person who was handling it. But if he feels comfortable to answer the question, there is no problem.
Chairperson, with respect, you've made a separate, a point that is separately valid, and that is, we know as a fact that the claims have not been pursued since the Judge Stuckman's
Yes.
order.
Yes,
And it may be inappropriate
Yes,
to
yes, yes.
So I withdraw the question.
Yeah, okay, well, that's fine.
Now, this is a report that's dated the 21st of November 2017. Is that correct, Mr. Mogashoa?
Correct, that is the date of the report.
All right. Now, let's go back to your affidavit, which is SS 13. In bundle G. After you submitted this report, what happened?
Can I interrupt you
Yes,
again,
yes, yes, please.
Mr. Soni? Please don't forget your question. I made a note in regard to this report, Mr. Mogashoa, to the effect that it did not deal with the merits of the claims, by which I meant it said nothing about prospects of success. And I think at the beginning of the report, there is a note you made towards along the lines that it should not be read as constituting your advice on the way forward or that kind of thing. You remember that note?
Would it be, Chair, on the first page of the report we just went through now?
Yes, yes, yes.
You look at paragraph 1.3, I think that's where you make the disclaimer, Mr. Mogashoa.
So I got the impression when I read that part that you did not want it. Your intention was not to say anything about the prospects of success, but it was just to say what has happened and where are we with regard to this litigation. Is that correct?
That is indeed so, Chair. I think my paragraph 1.3, if you look at it, it invites client to call for such a report if they need it.
If they need it, yeah, yes, yes, yes. I think the reason why I made that note may have been that I read somewhere, and I don't know if it was Judge Makubela's document, but I read somewhere, I think, where somebody said, but the report doesn't deal with the prospects of success or the merits. And I went to look at the report and I picked that up, that it didn't deal with that. But I think I only saw the note at the beginning of your report when Mr. Soni was pointing it out earlier. So you did not intend in that report to express any view on the prospects of success, but you expected client to approach you if they wanted such an opinion.
Correct. I think the update report, as I understood the instruction at the time, was that I provide status report on the nature of the claims and what our attitude as Prasa is towards them. And I think this is precisely what I did. We all know, as members of the same profession, how challenging such requests from clients are when you are expected to almost give some idea what the court would do with the cases in as far as the merits are concerned. So ours would be to be comfortable about the information and evidence that is available to us and advise our clients that we are of the view that the defenses would carry. And we were at that point prepared to follow through with that instructions to defend Prasa in all of these matters, given the information available to us at the time.
Okay.
Now, as I say, this report is dated the 21st of November.
Correct.
Thereafter, there is a report here dated the 28th of October from you.
Correct.
Well, before we get to that report, what led to that report being prepared by yourself?
After we dispatched with the report that we've just gone through of the 21st of November, I think a couple of days down the line, I received a call and an email from Mr. Dingiswayo, which had attached what we now know was a memorandum from the chairperson of the board, in which there were certain inquiries that the chair had put to, I imagine, Prasa's legal team or legal department, and in respect of which Mr. Dingiswayo's request was that I comment on the areas of the memorandum that made reference to our firm or to our involvement in the matters. And I think this is precisely how I then considered the memorandum that was available to me and prepared the second report,
Yes.
if I may call it that.
But before we get to your second report, let's look at the document that you referred to that Mr. Dingiswayo gave you. Have a look at MN6.
Of which bundle?
Sorry, that's an annexure to Ms. Ngoyi's affidavit, bundle E1, page 344.
Yes, I'm on it.
Is this the memorandum you're talking about?
I'm sorry, at what page is it?
Page 344, Chairperson.
On the same bundle?
Of Ms.
one.
Ngoyi's, of E1, yes, Chairperson.
If I'm not mistaken, I may have attached what I received at that time. I'm not sure if they are the same. If you allow me-
No,
I'm sorry.
sorry, I must apologize. Please look at MN5, not MN7.
What page is MN5?
338.
Page 33. Okay.
Is this the memorandum you received?
This is the memorandum I received. If you don't mind me checking, I may have referred to a memo as well. I just want to see.
Yes, it's at paragraph 23 of your affidavit, Mr. Mogashoa.
But did I attach it?
No, you didn't.
Okay, that's fine.
You referred to MN5 in paragraph 23.
That's fine. Then this is the memo.
Yes. Now, we don't have to go through the whole memo. There's just certain parts that I want to go through. Who is the memo addressed to?
It says here that it's addressed to the acting Group Chief Executive Officer, Mr. Zide.
Yes. And from whom is it?
It says it's from the Chairperson, Interim Board, Advocate T.A.N. Makubele SC.
And what is the date of the memo?
It says 28 November 2017.
And what is the subject matter?
CIA Consulting Engineering Pty Ltd, in brackets in liquidation, inquiry in terms of section 417(1) and 418(2) of the Companies Act 61 of 1970.
Now, this is a memorandum, this is a report. This is the section 417 report that you refer to quite often in your affidavit. Would I be correct?
Well, yes, it may be so.
I'm not saying you, I'm saying the reference is made to it.
I've made reference to it.
Now, until today, had you seen that report, the liquidation report?
You mean the report that is a subject matter?
Yes.
Here. No, I was never placed in possession of a copy of that report. I knew it existed, but
Face
a
this
copy
side,
was
and don't be too far
Sorry,
from
Chair.
because I can't hear you when you are too far from the mic, and certainly when you're looking
I'm beginning
away.
to like Mr. Sonny better, I see.
I see you are not the only witness who does that. I think a lot of witnesses like the evidence leaders more than the chairperson.
I
Yes.
think they're more intimidated by the evidence readers.
Thank you, Chair. To answer the question, I have not seen the report up until today.
Okay. Now, before we get to the report, and I just wanted to place it in context because that's the subject matter. This is addressed to Mr. Zide, the memorandum from the chairperson.
Correct, yes.
In your preparation for the CIA pleas and the developments thereafter, what communications did you have with Mr. Zide?
I think at that point in time, none whatsoever. I had been engaging with the legal department, and I think in the beginning I said Ms. Ngoye, Mr. Dingizwayo, and Ms. Mukotedi.
Those are the people with whom you dealt in regard to the CIA matters.
In regard to the CIA matters, correct?
And as at the date of this memo, had you had any dealings with the chairperson of the interim board, Judge Makubele, now Judge Makubele?
When you say dealings, are you referring to whether
Interactions, personal interactions.
personal interactions? Yes, when she was an advocate of the Pretoria Bar Council. I've had to work with her when I was at the previous law firm. I used to be a partner at Geldenhuys Manage.
But in regard to Prasa?
In regards to Prasa at this stage, no, not at all.
All right. Now, this memo was sent to you by Mr. Dingizwayo.
Correct.
Let's just have a look at what the memo says. If you look at paragraph 1, you could just read that into the record.
The memo says that I refer to various...
Sorry, could you see, identify to whom it is addressed?
It is addressed to Mr. Zide.
But the memo then starts off with,
Dear Mr. Zide.
yes.
And paragraph 1 thereof says, I refer to various discussions between us about this matter, as well as our brief discussion with the group executive, legal risk and compliance, Ms. Mathangoye, on 14 November 2017.
Yes. Then the next paragraph refers to your report, which we've just been through, That's MN4, would that be correct?
Yes, it refers to our report dated 21 November 2017.
And then she makes the point that Siaya DB had been placed under liquidation. That's the last paragraph, the last sentence of that paragraph. Would that be correct?
Yes, I'm aware that in our course of dealing with the group, some of their companies went into liquidation.
Right.
And at that time, which is November 2017, yes, we were fully aware as process legal representatives that there were liquidations proceedings that were or had been conducted.
Yeah. If you turn to paragraph 3, you see what the chairperson says about your firm's role in it. Just read that into the record, please.
It says it is not clear from the report of Mogashoa Diale attorneys whether they were subsequently appointed to represent Prasa to deal with the liquidation matter. As acting group CEO, such instructions would have come from you.
Well, if we could just pause there for a moment. Did you receive instructions from Prasa in regard to the liquidation matter?
Yes, correct, we did.
Right. And from whom in Prasa?
It would have been from legal, either the three Prasa colleagues I've made reference to. So because they would instruct me interchangeably. But when I communicate, I would communicate by to one and carbon copy the others. So I can't quite remember who in particular gave me the instructions, but the instruction came from either Ms. Ngoye, Mr. Dingizoye, or Ms. Mukotedi.
Would you copy Mr. Z there on those matters?
No, I did not have to.
And why do you say that? You didn't have to?
Because he had not been involved at any stage with any of the matters or in any of what we as legal representatives would have had to deal with on behalf of Prasa in defending the matters.
How long had you been acting for Prasa as at the time of this memo, which is November 2017?
You mean our firm or?
Yes, no, your firm.
Our firm has been doing work for Prasa since 2012.
And during that period, whom were your communications with, yours and your firm's communications?
It would have been with the legal department on what we call corporate matters, or it would have been with the insurance department if it is liability instruction.
But in regard to the litigation, with whom?
Corporate litigation, it would have been Mr. Ngoye, Mr. Dingizoye, or Ms. Mukotedi.
And what role would the CEO play in that process?
We have not had to deal with the CEO in respect of the matters we were dealing with at the time.
Then in paragraph 4, the chairperson makes a point about the arbitration, and she asks whether it happened before or after the liquidation application. Can you, well, just have a look at paragraph 4.
Must I read it out?
Yes, okay.
It also appears from the report that at some point the matters were referred to arbitration, but what is not clear is whether this happened before CIA Consulting engineers went into liquidation or not.
And can you shed any light on that?
I think if we had agreed, and I could be wrong, but my recollection tells me that at the time we agreed as parties to refer the matters for liquidation,
For arbitration.
for arbitration rather, information had not come forth at the time that there were liquidation proceedings in respect of this group of companies. But it came out that way before we could have arbitration proceedings to hear the matter that a group of companies, or some of them, had volunteered to be liquidated.
So the fact that there had been liquidation didn't affect the referral to arbitration. Would that be correct?
Not necessarily. I think on our side and for our part, we then encouraged the legal representative of the group of matters to give us the relevant Rule 7.1 authority to continue acting for them, even though there may have been a provisional liquidation order at the time, I can't remember, and which mandates we received from Mataupa attorneys.
All right. Then paragraph 5, perhaps you should read that into the record.
Paragraph 5 states that you are aware that attorneys acting for CIA consulting engineers approached on or about 14 November 2017, and that they provided me with a copy of an interim report of the inquiry in terms of the Companies Act that was prepared by the Commissioner and dated 15 September 2017. They also attached copies of email communication between Mr. Madimpe Mogashoa of Mogashoa Diale and Advocate Francois Botes SC. The email communication is also attached in Mogashoa Diale attorney's report.
Now, this interim report is the interim report in relation to the 417 inquiry. Would that be correct?
I imagine so. I can't say it with certainty, but the subject refers to that inquiry in terms of section 417.
But Mr. Mogashoa, let's get to, on a number of occasions in your affidavit, you say, I've not seen the report. What report are you talking about?
It must be this report.
It is this report.
Well, I accept that. I saw the report only today. So there will be challenges on my part to confirm with precision what all of these reports talk about when they talk about the interim report. I saw it only today.
Yes, okay. Now, in regard to this report, referral is made to it here, and then you thereafter met the chairperson of the board later, and at that, we're going to come to it, referral was made to this report as well. What was your attitude towards commenting on the effect of the report on the litigation or the prospects of the defenses succeeding?
Whenever the report would be mentioned, I would make the point that it would be difficult for me to comment on it in relation to the litigation without having seen it. And I made the point that although we had agreed at the conclusion of the liquidation inquiry hearings that the report be made available to us, redacted as may be, the report was never made available to us. I believe I made inquiries from our opponents whether they had received the report themselves or not. I don't think I received any answer that was positive in that regard. We may have also written to the Commissioner to inquire about the availability of the report, and we never got a copy of such a report until I started hearing about it around November, December, when we then were involved in meetings with Prasa, represented by the chairperson.
Now, in paragraph 6, the chairperson refers to certain communications from Prasa members. Could you just read that into the report and we can deal with that in a moment?
The report further reads on paragraph 6 that in their report, the Mogashoa attorneys indicated that they became aware on 20 August 2017 after receiving communication from Prasa that certain members have received subpoena to appear in the liquidation inquiry. They attended the inquiry but were not allowed to cross-examine witnesses. They also alleged that the commissioner has not provided them with a report.
Okay, and that paragraph continues on the next page.
Oh, does it? Then it continues to say, you have noted from the bundle of the documents from CIS attorneys that these assertions may not be entirely correct.
Now, just pause for a moment. This is she's talking about the assertions that your firm made. That's what the chairperson is talking about.
That's what I understand her to be saying, correct?
Well, are any of those assertions incorrect?
No, they are correct. Specifically, if it is about whether we had at that time received the report or the interim report or not.
And then she continues on, if you could continue with paragraph 6.
All right, it says, however, as acting group CEO, the instructions with regard to the liquidation inquiry, proceedings and handling of the High Court actions would have come from you. Kindly confirm the nature of the instructions that were given to Mogashoa Diale in this regard. Please attach copies of such instructions.
And what is your reaction to that? That the instructions would have come from Mr. Zide?
I think in the second report that I prepared, we deal with what is contained in the chairperson's report, and we clarify issues that may have at the time been of concern to us as a law firm. So obviously the instructions that our firm had been receiving up to that point were from legal. There would not have been any interaction between us and the acting CEO when it comes to the, say, a group of litigated matters.
All right. Then read paragraph 7, please.
It reads that it is clear from the interim report of the commissioner that the witnesses that testified at the liquidation inquiry include former and existing employees of Prasa. These witnesses would have attended the inquiry with your knowledge and understanding of the evidence that they were going to tender.
And then paragraph 8.
It reads that should the contents of the commissioner's report be correct, it is clear that the witnesses made major concessions with regard to the liability of Prasa in the civil actions launched by CIA Consulting Engineers, now in liquidation. However, despite these concessions, Mogashoa Diale appear to still want to proceed with the arbitration proceedings. They, however, did not address the prospects of success at that arbitration proceedings in view of the evidence that has already been led at the liquidation inquiry.
And then it continues. I want to ask you a few questions on paragraph 8. Just finish paragraph 8, please.
All right, it continues to say, kindly confirm if these are your instructions to Mogashoa Diale and the nature of evidence and witnesses that you intend to lead at the pending arbitration proceedings.
Now, let's just deal with the assertion that the witnesses made major concessions at the arbitration. Now, these are the Prasa witnesses. Let's get your role at the arbitration. You were allowed to sit for part of the Section 417 inquiry. Would that be correct?
Correct.
And that would be in regard to the Prasa employees.
Prasa employees, yeah, who were at the time still in Prasa's employment.
Yes. Now, in regard to them, where major concessions made, you sat in that inquiry.
It will be difficult for me to confirm whether they had made any concessions that were of any significance or not. I can tell you how we then tie up the proceedings, as was the case at the time. Questions questions we had never seen before were put to the witnesses. We were not allowed to participate by asking questions of clarity or asking questions to the witnesses and so forth. And this is why we immediately made the point that we would wish to be placed in possession of the report when it becomes available, particularly where it refers to the testimony or otherwise of the Prasa officials, because we would have had to then take instructions from our client thereabout. Now, the arrangements with the commissioner was that we as Prasa's legal team should facilitate some communication between the Prasa officials who testified and Mr. Makenza Mabunda, who I believe represented TCI, in order to establish whether there would be any agreement that may lead to either settlements or resolution of the matters. We then were engaged in numerous consultations with the same officials about what we understood the liquidations inquiry or commission to have been about. And there are reports that I filed that I refer to in my affidavit that confirm that we could not come up with any information which necessitated that we consider looking at the claims in the arbitration differently from what would have been the case before the liquidations inquiries.
So in effect, when you look at what happened at the liquidation inquiry, then you had these consultations, and the idea, as I understand it, at the liquidation inquiry was that Mr. Mabunda and these individual employees will get together to see if they could reach some figure as to what Prasa is owing.
That is correct.
You then wrote to the commissioner. Is that correct?
Correct.
And what was the thrust of your letters?
The thrust of our letters would be that we could not establish any facts that would have necessitated that we engage, or our witnesses engage with Mr. Mabunda with a view to within mind, perhaps to establish whether there could be some agreement on the amounts still owed, if amounts were still outstanding, and or that a settlement be looked into seriously more than may have been the case before. We as a Prasa's legal representative could not find anything that suggested that.
That the case that you had pleaded was a weak case.
That the case that we had pleaded was a weak case. I can give an example so that we get to we get somewhere in understanding what was before us at the time. When I was going through the report, you may have picked up that, for example, we would say that Prasa is not liable because there was no authority for Prasa to enter into such arrangements. as may have been pleaded. The witnesses may have been interrogated on the same works that we as external legal representatives are disputing that were authorized. So we won't be talking at the same level when I'm defending the matters by raising, for example, defenses like ultra vires or lack of authority, when the commission was dealing with whether those services, as may have been disputed by us already, were rendered or not.
So it was
Or whether
asking
the
a
invoices,
Oh, sorry. Carry on.
or whether the invoices it may have been an issue that dealt with whether invoices were submitted in return for services rendered, when our case was the invoices as presented to us are not in consonance with the annexures or the schedules that describe precisely what the services should be. So once again, without having had the benefit of what value the report carried in as far as the alleged concessions were made, it was almost impossible for us to make do of anything that may have had to do with the inquiry itself.
Then at paragraph 9.1, the chairperson says that she will contact, she needs a report from you on the defense strategy. Could you just indicate what she says specifically? Paragraph
Yes, Paragraph
9.1.
9.1 says, I will only and if absolutely necessary and appropriate involve former employees that testified after receiving a report from you and Ms. Ngoye, as well as Mogashoa Diala attorneys, on your defense strategy, particularly in view of the concessions by current employees during the liquidation inquiry.
And then she says at paragraph 10 that you should be advised what was going to happen next, and what was that?
It says that please advise Mogashoa Diala attorneys that I have read the report dated 21 November and that we shall revert to them before the end of the week, of next week rather, with instructions and a decision of further handling of this matter.
Now, did you receive instructions on the further handling of the matter?
What transpired after perhaps the conclusion of the second report?
Well, before we get to the second report,
In the context of what she says here, we never received any further instruction, particularly in respect of, or with respect to what she says in this report. And I think I deal with that in the affidavit.
yes. Now, in regard to this report, her memo of the 28th of November, did you prepare a second report?
Yes, subsequent, as requested by Mr. Dingizwayo, our firm prepared the second report.
And is that the one marked MN7 and appearing at page 356 of bundle E1?
Correct. That will be the report.
Before we go into the report, though, I just want to ask, because this, in a sense, was intended as a response to what the chairperson had raised in her memo to Mr. Zide. Is that correct?
Yeah, this report will speak to those areas that involved our firm. And I think that is what legal, through Mr. Dingizwayo, asked me to do.
Asked you to do. If you look at paragraph 1.1 of MN7, That's what it says, is given that the report was made available to us yesterday, we can only accept that the date, well, but that is the report that you are responding to.
Correct.
Okay. Now,
I'm sorry, Mr. Sonny. I think I was still focusing on something and you may have moved on to something else. I note that in the chairperson's memo that you have been dealing with, she says in paragraph 9.1, I will only and if absolutely necessary and appropriate involve former employees that testified after receiving a report from you and Ms. Ngoye, as well as Mogashoa Diale attorneys on your defense strategy, particularly in view of the concessions by current employees during the liquidation inquiry. Now, that this might not affect Mr. Mogashoa, but I raise it because it may be important in relation to her dealings with the legal department, because it seems that as at the date of this memo, she is still asking Ms. Ngoye, among others, to submit reports
yes,
about what she refers to as their defense strategy. And of course, she refers to Mogashoa Diale attorneys as well, in relation to the question of her, or of the allegation that she excluded the legal department. It will be important to try and establish from when did this alleged exclusion happen, because at this stage, she's still wanting to involve the legal department, at least in regard to the report. I think that it may be that in regard to giving instructions to the attorneys, she may be saying those must be given by the acting CEO. So I thought I must mention that we'll need to try and establish from when did the alleged exclusion take place.
yes.
Yeah.
I'm going to deal with that next, Chairperson.
Yes, okay. And of course, in the last paragraph, she does say the reports from you, that's paragraph 12, the reports from you, Ms. Ngoye, and the officials indicated in paragraph 9, that's the paragraph that I was talking about, must reach me on or before 12 o'clock on Friday, 13 November,
Yes.
to enable me to report to the Board of Control on 1 December.
Yes.
Okay, so there will be the question of whether, apart from the report from Mogashoa Diale attorneys, whether there was a report from other people that she mentioned in the memo.
Mr. Mogashoa won't know that.
Yes, no, I'm just mentioning it for
Yes.
some other time.
I would just, that's a matter that's dealt with by Mr. Dingizwayo, where
Yes.
he, on the 30th, submitted
Yes.
a report
Yes.
in response to this request for a
Yes.
report from Ms. Ngoyi.
Okay.
I suppose because he was dealing with the matter.
Yes, okay, so no, that's one. I seem to remember a memo from him or report that went to the acting group CEO,
Yes.
but was meant for the acting group CEO to pass it on, I think.
Onto the chairperson.
Yeah, so it's just important to link these two.
No, absolutely.
Yeah,
But to come back to the question, I'm going to raise it in the context of what happened after this, Chairperson,
Yes,
if
yeah.
I could.
Okay.
Now, after you submitted this report, I can say this report, meaning the report of the 30th of November, that's MN7, what happened next in so far as your dealings with Prasa went?
I think what happens next, according to my affidavit, is I was then called into a meeting at Prasa. Let me just see exactly where I deal with that.
At paragraphs 24 to 27, Mr.
Are you back to his affidavit?
To his affidavit, sorry, yes, Chairperson. That's SS 13 in bundle G.
Yes, and what paragraph are we now?
24 to 27,
24 to 27.
yes, at page 10, Chairperson.
Okay.
Would that be correct, Mr.?
That will be correct, yes. That's what happened next is what I say in paragraph 24 of my affidavit.
So let's, unless you want to read it, could you explain to the Chairperson what happened on the 4th of December?
Maybe before we do that, and I may have missed this, can we deal with what was different in their report of the 30th of November to 2017 compared to because the earlier report had been done about 10 days before.
Yes.
Yes. And what issues did it seek to address?
No, sure. So, sorry, can we go back to Ms. Ngoyi's affidavit, MN7,
Which page?
at page 356? This is your report of the 30th of November.
35. Oh, I'm on it.
Right. So, you then indicated paragraph 2 that at paragraph 1.6, you deal with the fact that you had received the chairperson's report. I take it off the 26th of November, is that correct?
I think it's 28th of November.
Yes.
That's correct, yes.
And then you deal with the questions that she had raised in that memo.
Correct.
Okay. The first question is the litigation and the voluntary, the litigation and the liquidation. In other words, which came first? You recall she had asked that.
Yes.
And in essence, what do you say?
I see. I will just summarize the paragraph
Yes,
without going
yes.
through them in detail. Well, the introduction that I give there is the fact that we had received instructions from Prasa between 2015 and 2016, and that my opponent is, or was at the time, Mr. Matopo Atenis. We summarize what was pleaded, or we make reference to what was pleaded in the various sets of particulars of claim. And then I make reference to a letter marked Annexure A, that makes reference to communication between the parties in respect of the need for the matters to be consolidated, and that we consider referring the matters for arbitration. I confirm there on paragraph 2.3 that Judge Brand was appointed as the arbitrator in the proceedings.
And then at paragraph 2.6, you say that those had been adjourned to the 26th to the 29th of March 2018.
Yeah, but there were dates in September of 2017.
Well, the dates were in September, were 11 to 22 September 2017.
Yes,
That
11.
appears at paragraph 2.5 of your report.
Yes.
And as at that time, that is now, as at the beginning of December or end of November, it appears that the matters, the arbitration, was set down for certain dates in March 2017.
Correct. This then means that I think around the time we're dealing with the liquidation inquiries, there was a problem with the issue of readiness to proceed. And I think we deliberated and discussed it between the parties, and I think Advocate Tsatsawane may have been instrumental in dealing with Advocate Waters about...
But the long and short is,
The long
it
short
was
is we
postponed to March
It was
2018.
postponed to March 2018
Yes.
for a variety of reasons, yes, correct.
All right. Then in paragraph 3, you deal with the section 417 inquiry, and you make the point in paragraph 3.1 that you do not have the interim report.
Yes, that's what I say in paragraph 3.1, that we do not have a copy of the interim report.
Yeah. And you then comment on the fact that the chairperson had been approached by the attorneys of the other side. And what do you say about that?
Is it paragraph 3.2 now?
No, 3.1 still.
Right. I say it is surprising that our opponents have gone on to do so and that they went on further to hand over documents to the chairperson, which documents purportedly carry some weight in enabling the parties to assess the claims properly.
So what were you referring to there?
I was referring to the interim report.
Yes. And the fact that the chairperson in her memo had said that she'd been approached by the attorneys.
Correct. The attorneys for the other side.
For the side,
Yeah, yeah.
yes.
Correct.
All right. Now, do you make the point that you do not have the report?
Then I make the point that I think despite numerous attempts at getting a copy thereof, I still did not have it at the time of finalizing this memo.
Yes. Then, in the rest of paragraph 3, you set out more or less what you've set out earlier about what had happened at the liquidation proceedings.
Correct.
Yes. And then at paragraph 3.11, you respond to the assertion by the chairperson that what you had said may not be entirely correct. And what was your response to that?
We're saying in paragraph 3.11 that to date, our office has not been placed in possession of any or all of the documents that may have been made available to the chairperson of the interim board. To this end, it is not certain to us under what or which context the chairperson concludes that these assertions may not be entirely correct.
Right. Then in paragraph 4, and particularly 4.1, you deal with the question of what the effect of the concessions, what effect the concessions might have on Prasa's case. What do you say about that?
We say there that although it has been Prasa's position that it is not liable to CIA in spite of the proceedings of the inquiry, we at this stage submit that it would not be possible for us to comment on how the alleged concessions made would now affect the crux of the defenses as pleaded in respect of each and every one of the defendant matters. We would need to have sight of the relevant documents that may have been given to the chairperson, including the interim report.
Now, were you ever given those documents, the relevant documents that you talk about?
I was never given any additional documents, no.
So that's the report that you sent on the 30th in response to the chairperson's memo of the 28th of November.
That's correct.
I see that in paragraph 3.2 of your report that you have just dealt with now, that you and Mr. Soni have just dealt with, you deny a statement made in the Prasa chairperson's memo in paragraph 5, where she says that, if I understand, you understand, yeah, where she effectively says that your firm, in your report, that is the first report, I take it, no, I may be mistaken, because they also attach copies of email communication between Mr. Madimpe, or that is the attorneys for Siaya, who she is talking about, where she says they also attach copies of email communication between Mr. Madimpe Mogashoa of Mogashoa Diale and Advocate Francois Borges SC. The email communication is also attached in Mr. Mogashoa, in Mogashoa Diale attorney's report. Or she says that email communication is also attached to your earlier report. You seem to respond to that in paragraph 3.2 by saying we would also like to clarify that our previous report of 21 November 2017 did not attach any of the email communication between our Madimpe Mogashoa and Francois Borges, and neither did the report make reference to any such communication. We will later in this report, however, append here to the relevant communication as may assist in clarifying some of these issues. So you confirm that in your first report, you did not attach any email communication, such as the email communication that the Prasa chairperson says in paragraph 5 of her memo you had attached.
That is correct, Chair, and I think in paragraph 3.2, we just wanted to clarify that.
Yes. So if she got any such email, it certainly was not from you.
They were not from my office,
Yes.
correct?
Chairperson, if I could put it in context, you will recall that attached, annexed to Mr. Bout's affidavit is the liquidator's report and the email communications that the chairperson is talking about. So so.
Or is she, maybe she could be saying, she might not be saying the email communication was attached to their report.
Yes.
But she might be saying the email communication between them and either Mr. Borges or CIA attorneys was attached to that report.
To that report.
Okay.
Because that's the report she received.
It's
from
just that last line of paragraph 5 of her memo says the email communication is also attached in Mogashoa Diale attorney's report.
With respect, she does in fact say that.
Yes.
But
So what I was seeking to confirm is whether that's factually true, because I read paragraph 3.2 of Mogashoa Diale's attorney's second report as denying that.
Yes.
Is my understanding in line with yours?
Yes, it is so.
Yes, and Mr. Mogashoa, you confirm that to the extent that she says in her paragraph 5, to the extent that she may be meaning that in your first report you had attached such email communication, you say that's not true.
Correct, Chair.
I was trying to
Obviously,
take
if she means something else, that's different.
No,
Yeah.
sure.
Yes.
I was just trying to make the point that there is no dispute
Yeah.
that she received it from Mr. Boat,
Yes, yes, yes.
because that
Yes.
Mr. Boat says so
Yes.
in their meeting of the 14th of November.
Yes, yes.
He handed her the report
Yes.
plus those.
Yes, yes, but
so-
of course, she says this email communication was attached to their report.
Yes.
And their only report she could be talking about at that time is the first
First
report.
report of-
And
of-
Mr.
of the
Mogashoa
21st.
says that's factually not true.
That is correct. Now, you say...
I
oh,
see
sorry.
that we have gone past 1, but I would like us to finish, if we can. I thought we would finish before 12 or around 12, but the matters we have dealt with are important.
Yes.
But I think we should be able, I don't know what your own assessment is in 30 minutes' time or so.
That's my assessment.
Yes,
Chairperson.
yes. So let's continue.
Yes.
But if anybody needs a comfort break, we can take that. But if we can move on and try and finish by 30:30, let's do so.
Yes.
Okay.
Now, on the 4th of December, if we could just summarize these aspects, please, Mr. Mogashoa. What happened on the 4th?
All right, on the 4th of December, I got a call from Mr. Zide, whom I believed was the acting Chief Executive Officer of Prasa at the time. You can't hear me?
Closer to the mic again.
Okay.
Yeah.
Apologies about that, Chair. I received a call from Mr. Zide, who indicated to me that the chairperson, Ms. Makubela, wanted to see me about issues related to their group of matters. My colleague and I, Ms. Mbebe, and I went to Prasa's offices. I imagine it was during the same day. We were
Okay, at paragraph 25, you say what the purpose of the meeting was. What was the purpose of the meeting?
Correct. I say there that at the meeting, the chairperson raised concerns about the fact that my firm was involved in formulating responses to her memo of the 28th of November, when she, in fact, had wanted the group CEO to respond, and perhaps with the assistance of the internal legal department, and that certainly...
No, but sorry, Ms. Mogashoa.
Yes.
I understand you are making a different point. If you read paragraph 25, her unhappiness stemmed from the fact that it was distributed to you.
Correct. I think I'm saying the same thing.
Okay.
Yes, that she expressed some discomfort at the fact that the memo was distributed to me.
Okay. Now, in regard to that memo, what did she want?
She did not say anything further than the fact that she expressed unhappiness about the fact that the memo.
Well,
had
if
been
you look
given
at
to me.
the rest of paragraph 25, you say she wanted you to hand the memo back.
Yes, I can finish my point around that.
Okay.
So she expressed unhappiness about the fact that I had been given the memo, and that she is aware that there may have been a report that I prepared in response thereto, and that she was not interested in that report. She asked that I hand back the memo, but I made the point that I had received the memo electronically, but if she wanted our firm to discard with the memo, we would do so when we get to the office.
Okay. Now,
I'm sorry, Mr. I see that you say that in that paragraph, you say that she said she was not going to accept your report of 30 November 2017, that responded to the memo, to her memo, insofar as your firm was concerned, given that her memo was not meant for you in the first place. Did she
Correct.
say that?
That's what she said to us.
Is your recollection quite clear?
My recollection is quite clear.
Didn't that surprise you?
Well,
Given her memo, even though may not have been meant to you, because in that memo, we just had a look, she wanted a report from a number of people, but those people included yourselves.
Yeah, but if you look at the memo, Chair, if you look at the memo, although she makes reference to our firm, in as far as some of the issues she was grappling with may have been concerned, her point to me at the meeting was that the memo was meant to be dealt with internally, and that she did not understand why legal thought it fit to pass on the memo to me to speak on, even if it's on the very same issues that perhaps concerned our firm at the time.
Well, I just want to check, because my understanding, and I think it was paragraph 9, no, it's not paragraph, yeah, it was 9. She says, I will only, and if absolutely necessary and appropriate, involve former employees that testified after receiving a report from you and Ms. Ngoye, as well as Mogashoa, the other attorneys, on your defense strategy, particularly in view of the concessions by current employees. You saw this report, even though she said it shouldn't have come to you. What was your understanding of this paragraph? Or have you no recollection of how you understood it at the time?
I understood, Chair, that legal was looking for assistance from my firm in as far as explaining, perhaps with more detail, what the liquidations proceedings were about, and what we made of them as Prasa's legal representatives, which request by legal I did not suspect was untoward. We had given them the first report. If more detail was required around issues to do with the liquidation inquiry, that's what I thought legal would have wanted us to assist them around. But at the meeting, fine, she took the point that the memo was not meant for a firm, and then in that respect, we did not even have to discuss the memorandum of the 30th of November, because her position was the memo was not meant for us. So that report we had drafted, we were not supposed to have drafted in the first place.
Of course, did your report of the 30th of November deal with what she called defense strategy? Because it seems that's what she wanted Ms. Ngoye and your firm to deal with in terms of paragraph 9. But again, she was saying, I will only, and if absolutely necessary and appropriate, involve former employees. So I think she was saying, if I am to involve former employees, I first need to have a report from Ms. Ngoye and Mr. Zide and Prasa's attorneys, Mogashoa, the other attorneys, telling me what the defense strategy is. Is your understanding the same as mine on what she was saying?
It is. The only thing is, up to that point, the only request I had received was from legal to comment on those areas of her memo that concerned our family.
No, I will come to that. I just want to check, is my understanding of what she was talking about the same as yours in that paragraph?
It will be, Chair.
If she was to involve former employees, she would need a report from Mr. Zide, Ms. Ngoye, and Mogashoa, the attorneys, on what the defense strategy is. We are on the same page.
We are on the same page,
Yes.
correct.
Now, were you asked by either Mr. Zide or the legal department of Prasa to prepare a document that dealt with Prasa's defense strategy in regard to the CIA matters?
Not at that point of
Yes.
the 4th of December.
Not around that time,
Not around that time.
and not after, actually.
Not ever after.
Yes, okay, all right. And just to confirm, your report of 30th November did not deal with that. We did not deal with the defense strategy that she was talking about.
No, it did not.
Yes, okay. Mr. Sonu?
As you please, Chairperson. And then she pointed out that she was not going to look at the memo of the 30th of November that you had prepared.
Yes, that's correct.
And
I think if we call it a report, let's be consistent.
No,
Otherwise, somebody who read this transcript after some time will think there is also a memo of 30th
Yes.
November
No,
and a report of 30th November. Okay.
Now, forget the fact that the memo, her memo of the 28th was not meant for you. You take the trouble, having received instructions from legal, to prepare a report.
Correct, that's what happened.
And I think that's the point the chairperson is making, that the board chairperson now says, I'm not looking at it. Did that not surprise you?
I was surprised.
Right. Then,
I'm sorry. If we take it that she was not interested in your second report, and that therefore she did not look at the report, are you able to say what perspectives or knowledge she deprived herself of in regard to understanding this matter better? Or would you not be able to say? Because your report would have dealt with certain issues, and I take it there would have been a need for such issues to be clarified, given that you had just prepared another report.
I took time under serious constraints to prepare the second. And for me, in the context that I understood her memo to have been asking for a bit more information, I thought that would have been information relevant to some of the inquiries she had made, albeit that she did not expect that I would add to her memo. But I thought they were relevant submissions to bring anyone on board about or regarding the issues that were confronting all of us in respect of the CIA matters.
and from the Prasa side, only you and counsel had attended the Section 417 inquiry. Would that be correct?
It will be my team, meaning Ms. Mbebe and myself and the council team, and of course the officials of Prasa, or from Prasa that had received subpoenas to us.
Yeah, but they were witnesses.
Yeah, they were witnesses. Otherwise it will be just us. Ms. Mukotedi may have come for a short period, either on the first day or the second day that we appeared. but she came very briefly, and I could be wrong in suggesting so. But she may have come through to join us for a while.
Now, in regard to the interim report of the insolvency inquiry, what transpired or what discussion transpired at this meeting of the 4th of December?
At the meeting of the 4th of December, I do not believe that we got to the details of that report. I think what I was then told by the chairperson was that the board would take a view on how to proceed with these matters, and if needed, what our firm's further involvement would be.
Did you explain to the chairperson the disadvantage you were under as a result of the fact that you didn't have the report?
The discussions did not go that far, given the fact that she did not want to get into the details of my report of the 30th of November.
Did you tell her that you had not seen the interim report?
Let me just refresh my memory, because I think paragraph 26 says something of my affidavit about the report.
If you look at the third line from the top, from the bottom, I made the point.
All right, then it means she mentioned the report, and I'm saying I made the point that I did not have the report she was referring to, despite that I may have called for it prior to our meeting. She voiced out concerns about how Prasa was now going to deal with the report and the arbitration proceedings, which at the time had been postponed to March, given the evidence of the employees of Prasa.
Right, and in the last sentence of that paragraph, again, 4 lines from the bottom, you start off with, I made the point.
I made the point to Ms. Makwela at the meeting that it was not going to be possible for me to comment on her concerns without the benefit of having seen the contents of the interim report and the insolvency inquiry myself.
All right. How did the meeting close?
I think as far as I
Maybe before it closes, I'm not sure that you have dealt fully with this issue of the interim report in terms of what transpired between you and the Prasa chairperson. And I realize you needed to refresh your memory. Do you want to just to tell me again, how did the interim report come up in the conversation? What did she say? What did you say? If you need to refresh your memory, you may refresh your memory, but I just want to hear fully what transpired at that meeting.
Okay, at the time I was dealing with this issue earlier, I was under the impression that the report was discussed at the next meeting that followed. But I see that paragraph 26 and maybe into 27 makes reference to the fact that she raised the issue of the report at the meeting. I indicated that I had not seen the report. I was never placed in possession of that report, and that therefore it was going to be difficult for me to make any comments about the value that and the weight that the report carried in the context of the litigated matters before the arbitration that had been intended to follow in March of 2018, and that I had nothing more to offer her other than that perhaps if the report were to be availed to me, then I can act on it and consider it and do what would have been necessary for me as as Prasa's legal representative to do, given the contents of the report. And I think it did not go any further than that, except that, but that I must point out that we then were told as a firm that that Prasa will revert back to us as soon as she has some idea about what Prasa's attitude is towards the report and the matters in their entirety.
Was this your first meeting with her in regard to Prasa matters?
It was my first meeting with her, yes, on the 4th of December.
Okay.
As you please. Now, who all was present at that meeting?
It was myself, it was Ms. Mbebe from our office, it was Mr. Zide and the chairperson, Just Makude.
Okay, so would that mean that nobody from the legal department, but particularly Ms. Ngoi or Mr. Dingizwayo, was present?
They were not present at that meeting of the
Did that
4th of
surprise you?
Well, yes, it did. It did surprise me that they were not part of the meeting.
I take it from what you have said about what transpired at that meeting that you did not expressly ask the Prasa chairperson to let you have a copy of the interim report.
I did put it to her that it would be helpful that I be placed in possession of the report.
Yes.
Yes, I did.
You did put
say
it that way,
in
yes.
the meeting.
Yes, and did she then offer you a copy of the interim report?
Not at that stage. I was told that Prasa will get back to us
Yes.
as a firm on what the decision is in dealing with the matters
About going forward.
So at that point, I did not receive, or I was not given a copy of it.
Yes. Okay.
So did you get the impression then that this decision was going to be made without any further input from you?
Well, you can accept that at that point, Chair, I was not aware what decisions Prasa was likely to make. I was told that I would be contacted as soon as there was some idea regarding what to do with either the report or the matters, and that is precisely what happened thereafter.
It's quite clear from what you have said in regard to, I think, that meeting, but also in regard to the Prasa chairperson's memo of 28 November, that she believed that certain employees of Prasa had made major concessions with regard to the CIR claims. And it would seem that she was, she implies that what she regarded as major concessions made by those employees would play quite a significant role in the decision about the way forward. That's the impression I get from her memo and from what you tell me. Is that an impression that is the same as the impression you had then, or not at that stage?
That's the impression I got, that she was worried about what leg then Prasa would stand on in further continuing to defend the matters, given the contents of the report. And this is why I repeated on many occasions that without the benefit of the interim report, there could not have been any more that our firm could say other than to accept that there is a report in existence somewhere.
And of course, in her memo of the 28th of November, she specifically made reference to requiring to be told by Mr. Zide, Ms. Ngoye, and your firm what the defense strategy, what Prasa's defense strategy was to the CIR claims. Is that right?
That is indeed so.
But she did not, at the meeting of the of the 4th of December, as I understand your evidence, say to you, what I would like from you is to tell me either now or to furnish me with a document that tells me what your defense strategy for Prasa is. She did not say that, did she?
No, Chairperson, no, she did not say that.
At the meeting of the 4th.
At the meeting of the 4th.
Yeah, and
I was not asked to make any further representations about my impressions of, or my impressions of
the defense.
of the defense, with or without the report of or the interim report
Yes.
of the commissioner.
Yes,
I was not asked to make
yes,
further
Any
representations
inputs?
around that.
yeah, okay.
Just one final question on the persons who were present. Did Ms. Makubele ask at that meeting, ask Mr. Zide where the members of the legal team were?
Not to my recollection. If she did, perhaps I was not there.
Not during your presence.
Not during my presence.
Oh, okay.
All right.
Are you told anything about why they were not there?
No, nothing was explained to me, but you would see that in paragraph 27 of my affidavit, I do say that I called them immediately thereafter because I had to, it was the first time that I was interacting on the matter at Prasa with Prasa officials other than them. So I called them to say to them, that's the meeting, the chairperson is not happy about the fact that our firm was asked to comment on the memo and that I was told that Prasa will get back to me in due course.
Yes.
Then there was a further meeting between you and Ms. Makubele.
Correct.
And when was that?
I think we do deal with that. On paragraph 28 of my affidavit, I make reference to the fact that on the 14th of December, I received a call from Mr. Zide, who indicated...
I'm sorry, Mr. Soni and Mr.
As you please.
Just looking at the last part of your paragraph 27, when you told Ms. Ngoye and Mr. Dingiswayo and Ms. Mukoteti about your meeting with the Prasa chairperson and Mr. Zide on that day, did they say anything about their absence at the meeting? Or did they seem to know about the meeting at all? Or is that something you can't remember?
It's something I can't remember because I think I placed emphasis on reporting back to them that the chairperson was not happy.
Yes.
And that I was informed that the members of the group legal then would have to explain to her what happened, much as I was told at the meeting that Prasa will get back to us as a firm, should that need be there.
Yeah, okay.
All right, then the next meeting, you say, took place on the 15th of December.
Yes, I got called on the 14th.
By whom?
Mr. Zide, that the chairperson wanted a meeting with us on the CIR matters the next day.
All right. Now, did that meeting take place?
Yes, the meeting took place on the 15th. I did not state the time because I can't remember what time the meeting was. And I think present at the meeting was the chairperson, Mr. Zide, and myself. I can't remember that anyone else was there.
Okay. But certainly not Ms. Ngoyi and Mr. Dingiswayo.
Certainly not Ms. Ngoye or Mr. Dingiswayo.
Did Ms. Makubela ask Mr. Zide where Ms. Ngoyi or Mr. Ndingizwayo were at that meeting while you were there?
If there was ever that conversation, I don't have any recollection of it.
And if it had taken place, would you have remembered it?
I would have, perhaps. I imagine so.
Okay. Now, anyway, at this meeting, if you could just briefly summarize what happened there.
All right, I got called into the meeting, got onto the meeting with my files. And by my files, I'm referring to the two reports, because I thought that the meeting would be about the two reports that I had prepared. I think two key things were tabled as agenda items. The first one was that after having given regard to a variety of issues and factors, and in particular the evidence as may have been contained in the interim report, that Prasa's attitude was that there be some attempt at settling the matters, and we then went into the. I must then obviously at this point say that, well, if those would be Prasa's, if that would be Prasa's attitude, I would accept it. But I made the point further, I think at that meeting, that I do not know, I wouldn't know what the considerations are, given the fact that still at the time I did not have the report or the interim report, but that I would accept Prasa's position if it now prefers that it settles the disputed matters with the group. We then got into some bit of detail on what Prasa thought it wanted to do, and this is through obviously the chairperson and Mr. Zide. I speak about it on paragraph 31, subparagraph 31(1).
Well, before you go to paragraph 31, please go back to paragraph 29.
Yes.
You were told that, well, were you told who would be dealing with the matter from now on?
All right, when I said two issues, Chair, earlier on, one of the issues that was raised was that I then would have to accept that the matter was no longer the responsibility of legal, and that the board was now seized with the responsibility of dealing with the matters further. I was given instructions that from that point onwards, I would have had to deal with Mr. Zide. I can't remember whether at the time he was still the acting group CEO or he had reverted back to his original position of the company secretary. But I was told that the matters will be dealt with by the board, and communication to my office will be through the office of Mr. Zide, and that at that point, I was advised that there was no need then for me to continue discussing the matters with members of the legal department.
With regard to Mr. Zide's position at that time, and you don't need to go there, Ms. Ngoyi in her affidavit says that Mr. Zide from the 7th was no longer the acting CEO. Mr. Malope became the acting CEO, and Mr. Zide reverted to his earlier position of chairperson of the board. I'm just placing that.
Oh, yes, oh, yes. But the instruction was that whatever communication between our firm and Prasa would be through Mr. Zide and Mr. Zide's office.
Now, in regard to the fact that you were no longer to communicate with Prasa Legal, what was your reaction to that? Not expressed necessarily, but I'm just saying your personal reaction to it.
Well, Perhaps let me respond by saying that it is not unusual that we receive such instructions in our firm, given the profile of some of the clients we have. So it has happened before that the CEO of an institution would request us not to deal with legal, perhaps because legal was the subject of whatever investigation we had to carry out. It is not unusual for the board to consult with us and provide us with instructions to that center around investigations of a CEO of a company. So to that extent, and when I was told that the board has decided to take responsibility for such matters, I was not overly perturbed by that instruction. It was followed by another instruction that communication should happen through the company secretary. It's not unusual that company secretaries would carry that or such responsibilities as may be required by the board. So in that sense, I was not overly perturbed by the chairperson's position that the matter was now in the hands, the matters were now in the hands of the board, for the board to deal with.
Actually, you are not perturbed at all.
I was not perturbed at all, yes, correct. Correct, Chair.
I just noticed you were saying not overly perturbed, but I thought your explanation must mean you were not perturbed.
I was not perturbed because we do receive such instructions from the institutions we carry work out for from time to time.
Would you get to know in other instances why, for example, the legal department why you would be required not to communicate with the legal department or to get instructions from them, but rather the CEO? Or would you just be told, be told that from now on it's the CEO's office that will deal with you without being told anything else, like, well, there are some investigations about concerning the legal department or anything like that?
Well, other than that, there would be
some explanation?
well, or that whatever investigation or instruction related to a member or members of the legal department or the head, for that matter.
Yes.
We then find ourselves dealing with other functionaries other than legal in such, and we do understand that.
Yeah, okay.
So, some of the matters we would do on behalf of boards would be matters that have to do with boards, and they may contain information that relate to functionaries which the board did not wish that the functionaries gain access to, at the very least through us.
Yes.
So
So it does happen.
It does happen.
Yeah, okay.
But this was unusual, and I'm going to suggest to you why. Immediately after the meeting, you phoned Mr. Dingiswayo and told him about that instruction.
Yes, immediately after the meeting, I called Mr. Dingiswayo and I mentioned to him that I was told that the matters now are in the board's hands and that there was no need for me to be discussing them further with legal.
So I'm going to suggest, Mr. Mogashoa, that that's quite different from the examples you've been giving us. You're told don't consult with them, don't talk to them. But that's exactly what you do. I'm asking then about your reaction to that instruction.
Maybe before that question, let me get clarity as to what precisely the chairperson told you with regard to any further dealings between yourself and the legal department of Prasa. At one stage, I think in your affidavit, you say something to the effect that she said there was no need for you to deal with the legal department of Prasa or to take instructions from them. But I think elsewhere you put it more like an instruction. Now, if she says there is no need, it might not be an instruction not to deal with them. It might simply be that you won't have to get instructions from them. You'll now get the instructions from us. So if you talk to them, I don't see any need why you should talk to them, but I'm not saying don't talk to them. But if you say it was an instruction not to talk to them, then it has a different connotation. Precisely what was it? What did she say?
Just to assist you, Chair, it was an instruction, and this is precisely why I contacted Mr. Dinkizwayo.
Yes.
I contacted him for two reasons. The first being that I wanted to manage legal department's expectation of me telling them what further instructions I have from the board. And secondly, because I, at the time, was dealing with many others of their instructions, I did not want to find myself in a difficult position where we now get into discussing the CI matters. When I had been given an instruction not to discuss the CI matters with them, and we so I don't know what I've done here, and we continued to interact on other matters or in respect of other matters without necessarily getting into the issues to do with the CI matters.
Well, that's important because I meant to ask you later on whether the CI matters were the only matters you were handling on behalf of Prasa or whether there were other matters. From what we have said now, it seems that there were other matters on which you had instructions from Prasa other than the CIR claims.
Correct, Chair. There were other matters that I was dealing with.
Are you able to say it was 2 or 3, or are you able to say it was a number of them?
It was a number of them.
Yes.
I was doing quite a fair number of
work
litigation matters on behalf
Yes.
of Prasa
Yes,
Corporate.
you might not be able to be precise in terms of the number, but are you able to give an estimate more or less 10, more than 10? Or?
There may have been, at the time, 6, 7, or 8
Matters.
other unrelated,
Yeah, that's
Matters.
apart from the CIR matters.
apart from CIR,
Yes.
that were in arbitration
Yes.
forums or
Yes.
that they were litigated out of the High Court.
Yes.
And mostly we acting as defendant.
Yes.
can't
So
imagine
Prasa
what
had
else.
been sued.
Prasa was being sued, correct?
Just for the sake of completeness, did the Prasa chairperson at any stage ever interact with you in regard to the other matters you were handling on behalf of Prasa other than the CIR claims?
Not to my recollection, Chair. I think to assist you further with your question, I do not believe that I have, since the meeting of the 14th, that I had any further interaction or engagements with the chairperson of Prasa.
Yes, but I'm also asking even before that meeting of the
No.
14th, whether you had any interaction with her with regard to claims against Prasa that you were handling on behalf of Prasa other than the CIR claims.
I was called to come and discuss with them only the CIR matters.
Only the CIR claims.
Correct.
The other ones that you were handling, were also pending in either court or arbitration.
Correct, that is indeed so. Some of them are still very much alive to this.
Yes, okay, thank you. But going back to the earlier question, are you quite clear in your own mind that what she gave you in that meeting was an instruction not to discuss with the legal department, not to discuss the CIR claims with the legal department of Prasa? Are you quite clear? Is your memory quite clear on that?
My memory is quite clear. I called Mr. Dingizoyo. I see Mr. Dingizoyo speaks about it in his own affidavit.
Yes.
But if you look at the fact that our firm then strictly started communicating with the office of Mr. Zide only,
Yes,
that as well would
yes,
confirm that the instruction to me was clear,
yes,
that I should communicate with only the office of Mr. Zide,
yes,
or through the office of Mr. Zide,
yeah, okay.
if I may put it
Mr.
that way.
Sonny.
As you please, Chairperson. What was Mr. Dingiswaya's reaction to that communication? That, look, I've been instructed not to talk to legal.
He was surprised. We did not have a lengthy discussion, but he was quite taken aback by my having said to him that the chairperson has instructed me to deal with the board through Mr. Zida's office only.
Right, then at paragraphs 30, 31, and, paragraphs 30 and 31, you make the point that at the end of the day, the chairperson again raised the question of the 417 inquiry, the adverse effect it would have on Prasa's prospects of successfully defending, and then you say that you were told to settle 4 of those claims.
Correct.
Is that what happened?
That is what happened. Yes.
Now, I'm not going to go into the settlements now because you later on say that there was a written instruction on precisely how the matters were to be settled. We'll come back to that. Then at paragraph 32, you make the point that you were given an instruction about how the settlement agreements were what to include in the settlement agreement.
I'm sorry, Mr. Sonny. You said you are going to skip these settlement agreements because later on he talks about a letter.
Yes.
But is it not better to deal with it because now in 32 he's talking about a clause that was meant to be in the settlement agreement or the issue of confidential, but we don't know yet that he has been instructed. So I think logically we should hear that
Yes.
he gets instructions to settle on whatever terms and
Yes.
then,
As you please.
yeah.
So in paragraph 31, you set out the manner in which you were to settle each of the 4 claims that are mentioned there. Is that correct?
That's correct.
All right, let's look at 31.1.
I'm sorry. Are you still at that one dealing with what transpired at the meeting of the 15th of December? It looks like. Are you still in paragraph 31 dealing with what transpired at the meeting of 15th December?
Correct, Chair.
Yes, okay. Okay, to deal with that.
So at this meeting now, you are told that 4 of the matters are to be settled, and you are given the figures at which you must settle them. Is that correct?
I'm sorry, Mr. Sonny. What did Ms. Makubela say about the settlement of the CIR matters at that meeting?
Chair, I'm not sure I follow, but
I just want to, did she say anything about the CIR claims being settled at that meeting? I just want you to
Okay.
tell the
All
story.
right. Okay, that's fine. I think I understand what
You deal
want
with
us-
it at paragraph
want me to assist with this.
30, the last part of
Paragraph
paragraph 30.
And you can refresh your memory, but I just want you to relate to me the story.
All right, I think the summary, I can summarize paragraph 30 to be that the chairperson put to me that given the contents of the interim report and perhaps other factors, Prasa had decided that it will be in its best interest that it attempts to settle the matters with this group, given that she was concerned about the fact that we may not have evidence that is adequate or sufficient to sustain proper defenses in light of the fact that the interim report suggested to her that there were concessions made by the Prasa witnesses. And I think I made the point to her once again that I can't comment on the report, but I do hear what she's saying about Prasa's intention of negotiating a settlement with this group for the reasons she advanced. And I said to her that our firm, as a creature of instructions, would then need to be instructed in writing about what offers Prasa wanted to make to this group. And I don't want to get ahead of you, Mr. Soni.
Yes, no,
We discussed the four
amounts.
matters that Prasa said it was in a position to make offers on.
Yeah, Mr. Soni can take it from there.
Yes.
As you please, Chairperson. And then she indicated a figure at which each of the matters must be settled. Would that be correct?
She indicated figures which she thought would represent offers to be made.
So have a look at 31.1, and that dealt with which case number?
31.1 dealt with case number 47597 of 2016.
And what was the amount that was in respect of which a tender had to be made?
The amount here is 17,178,853 rand.
Don't lower your voice.
Oh, yes,
Don't
yes,
lower your
Chair.
voice.
Okay. I may be beginning to run out of energy. But I'm still okay to continue.
Yes, okay.
And then at 31.2, what case number?
It's case number 47598 of 2016, and the amount thought of at the consultation was 15,371,739 rand, 87 cents.
And the one at 31.3?
It is case number 73933 of 2015, and the figure that Prasa thought of at the time was 8,095,950 rand.
And 31.4?
The case number is 73934 of 2015, and the figure that Prasa had in mind at the time was 7,098,481 rand, 0.66 cents.
So in essence, orally now, your instructions were to settle at those amounts.
That's what I was told that Prasa wanted to do, make offers in these amounts.
And that's what that you would do in writing to the CIO attorneys.
I didn't get the question, sorry.
I say those offers would be made in writing to CIS attorneys.
Well, the point about that things be in writing was the point I made at the meeting, that I would prefer to be, I was just taking sketchy notes of what I was told, because I said I would act on written instructions as soon as I received written instructions from Prasa regarding what it had intended to do.
So, although this had been given to you orally, you were requiring that Prasa puts in writing what the amounts are and what the terms of the offer are.
Correct.
All right, but at paragraph 32 then, you make the point that the chairperson required a particular clause in regard to the settlement agreement.
Yes, I make the point that we were asked to include a confidentiality clause in the offers that we were instructed to make, and that such offers be made without admission of liability, given that they were purely for settlement purposes.
Mr. Soni, I know that we wanted to finish earlier, and I know that at 1 o'clock we had thought we would finish by past, but we haven't, and it's not anyone's fault. But maybe we should just take a lunch adjournment.
Yes.
Mr. Mogashoa, I see you certainly would like us to finish before. I'm just realizing that we are at 2 o'clock, and I think that we might find ourselves getting to 3 o'clock without lunch. Mr. Mogashoa, have you got a consultation set up for 3 o'clock?
Well, I don't know how much longer Mr. Soni is of the view we will take, but I'm for my, if I were to speak for my part,
Yeah.
I'm still comfortable to continue.
Yes.
Because I would rather have us finish the proceedings so that then I can head off to Pretoria to do what I still can. But I'm not opposed to lunch being taken.
Yes. No, certainly we will finish today. It's a question of whether we take the lunch now. So I think we have tried to finish so that when we take the lunch break, we don't come back, but we haven't succeeded. And it's not anybody's fault. So maybe let's take the lunch adjournment, come back at 3 o'clock, hopefully fresher, and then that might even assist to speed up, because I think we might all be a little exhausted after sitting from about, 10:30, 10:15, except for the tea break. Let's take the lunch adjournment, and then we'll resume at 3 o'clock. We adjourn.
I'm sorry. That's what happens when you don't read your